I'm going to start out with Judge Douglas. I'm interested in how you read the Constitution and statutes. The Fifth Circuit regularly fields constitutional questions. Do you believe in the principle of living Constitution?
Thank you, Ranking Member Grassley, for that question. I do not believe in the Constitution being a living document. I have approached each case that I have presided over by first reviewing the text of the statute or the provision that is before me, by making sure I listen intently to the arguments of counsel.
I think you've given me a good answer. Let me go on to the second one. Do you believe that the meaning of a statute can change over time? Now we're talking about a statute that only Congress can change.
Thank you. Again, my practice since the time that I have presided as a United States Magistrate Judge is to focus squarely on the text that is before me, and if that text is clear, I apply the law as written to the facts of the cases before me. I look to the precedent of the Fifth Circuit and the United States Supreme Court in order to assist me in applying those principles to the facts of the case that are before me.
Okay. I'll start. I may come back to you, but I want to go to Mr. Garcia. There was a leak in the Dobbs case. Protesters have taken to picket and parading outside the justice's home. It seems like an obvious attempt to influence the court's decision. The Justice Department has refused to enforce this federal law. You serve as Deputy Assistant Attorney General for the Office of Legal Counsel. Often the Attorney General asks this office to weigh in on important questions. Has the Justice Department concluded that this statute is unconstitutional as applied, or is the Justice Department refusing to enforce the law for some other reason?
Thank you, Senator, and I appreciate the question. I can say that have not been involved in any analysis of that type. One thing that I would say is that having clerked at the Supreme Court and seeing how the justices do their job, I have every confidence that the justices and their staffs are carrying out their constitutional duties without fear or favor to outside pressure.
As a lead-in to my next question, you litigated against Catholic schools in a case before the Supreme Court, arguing that federal courts have the power to intervene in employment decisions involving teachers at religious schools. Your brief acknowledged that teachers at religious schools serve important religious functions, but still claimed that the so-called ministerial exception shouldn't apply to them. Now, a majority of the Supreme Court, including Kagan and Breyer, disagreed with you. Why, in your view, should the protections of the First Amendment not apply to employment decisions at religious schools?
Thank you, Senator. I have great respect for the First Amendment values that are the basis of the ministerial exception. And in fact, in other cases, I've represented plaintiffs bringing religious exercise claims that rely on similar principles. As to those specific cases, my firm was retained by the plaintiffs, and in that capacity, our firm advocated zealously for that position. That was actually only the second Supreme Court case ever to consider the scope of that exception, so there was significant uncertainty. And now, of course, as you noted, the Supreme Court issued a decision, and if I were confirmed, I would have no hesitation about applying the court's holding and the guidance it set forth.
My last question will be to you, Mr. Garcia. You fought against the construction of border wall in El Paso versus Trump. Your argument, among other things, was that the president couldn't use funds earmarked for counter-drug activities to build the wall, given that securing our southern border would reduce the influx of lethal drugs like fentanyl. Why is it inappropriate for the executive branch to use funds earmarked for counter-drug activities to secure the border?
Thank you, Senator. I actually became involved in that case only at the Supreme Court level when the clients were considering seeking Supreme Court review because of my past experience with similar petitions. As to the specifics of that case, it was an intricate statutory interpretation issue about whether certain appropriations could be used to certain ends. And beyond that, that was the scope of my involvement in that case.
Thank you.
Thank you, Senator Grassley. Senator Feinstein.